Hello everyone, I am Ashutosh Jadhav, Associate at HSA Advocates, and in today's discourse, I shall expound upon one of the most frequently litigated and legally sensitive instruments in the Indian real estate domain, the Joint Development Agreement or JDA. Our focus shall be on the confluence of JDAs with imperfect title and how failure to fortify the title foundation may invite a torrent of civil litigation, tax scrutiny, regulatory breaches, and criminal exposure. Let us commence. What exactly JDA is? It is a legally binding arrangement wherein the landowner contributes the land or equity as a licensor and the developer undertakes construction, obtains permission, arranges financing, and markets the resultant property. The consideration is typically in the form of revenue sharing, area sharing, or a hybrid mechanism. Such agreements are executed under the Indian Contract Act 1872 and may entail transfer of rights falling within the ambit of Section 53A of the Transfer of Property Act, which recognizes the doctrine of part performance, where possession is transferred in anticipation of performance. Now, the title becomes the core of all the JDAs. The concept of marketable title is central to all the JDAs. A marketable title is one that is free from reasonable doubt, encumbrances, litigation, adverse possession, easementary rights, benami ownership, or statutory non-compliance. The key provisions for the same is Section 55 of the Transfer of Property Act, which mandates that the vendor disclose all the material facts in the title. A title-filled encumbrance is also a key requirement under RERA, especially under Section 4 of the RERA. Developer must avoid any oral assurances, unregistered documents, or pending litigation under Order 1, Rule 8 of the CPC. Moving ahead, there are certain pre-joint development agreement legal due diligence checklist, which talks about 30 to 40 years of title search as the core of it, which talks about the chain of title in the past 30 to 40 years. This essentially comprises of sale deeds, gift deeds, partition deeds, and the release deeds. This also includes any probate order if title is devolved via will or intestate, any court decrees under Section 96 of CPC, or any other power of attorney scrutiny under Section 85 of the Indian Evidence Act. Now, there has to have an encumbrance certificate, which is supposed to be obtained from the sub-registrar office. It must reflect all registered transactions affecting the land. This also comprises of revenue records and mutation entries. Even though mutation is not conclusive proof of title, but absence of mutation may reflect incomplete possession for the litigation. Now, the review varies from state to state. In Maharashtra, we have Form 712 extract. In Tamil Nadu, we have Patta Chitta extract. In Karnataka, we have Khata and RDC. And this varies from the state to state jurisdictional practices. Now, the land use compliance also has to be confirmed by the developer while using such land, which is urban development limits, which is master and the zonal plans. Permitted zoning plans, which pertains to residential zoning, commercial zoning, or the industrial zoning. There also has to be a cross-check whether such land is not falling under the green belt, buffer zone, or any other environmentally restricted zone. The same has been governed under Environment Protection Act of 1986. Moving ahead, there is certain checklist for the for the landowners as well, which comprises of verification from the MCA master data for ROC compliances. A landowner also has to verify whether is there any insolvency proceeding going against any such developer before NCLT to check the RERA complaint history of such developer, which is available on the state RERA portals, to check whether such developer got blacklisted under Urban Development Department circulars or not. As a landowner, it becomes really very important to draft the JDA with the specific clauses, which comprises of development timeline, profit area sharing formula, indemnity and representations, dispute resolution clauses. Now, the registration of such JDA has to be done in accordance to the Section 17 of the Registration Act 1909. Effect of such non-registration is governed under Section 49 of the Indian Registration Act, which says dismissal of claims for specific performance if not registered under Section 17 of the Indian Registration Act. Now, the stamp duty also becomes the really very crucial part of it, that all the JDAs are supposed to be duly stamped. In Maharashtra, Karnataka, Telangana, and Tamil Nadu, a JDA with GP attracts duty up to 5%, calculated either on the market value of the land or the developer's shares, whichsoever is the higher. But this again varies from the state to state. Moving ahead, the taxation on such JDA is governed under Section 45 of the Income Tax Act. Moving ahead, while doing the title check, there are certain problems which a developer may encounter. The first one would be undivided ancestral property. Title without partition may be challenged by co-partners under Hindu Succession Act. Improperly executed power of attorney must be executed by the principal, authenticated as per Section 32 of the Registration Act. Unprobated will. In testamentary succession, especially under Indian Succession Act, will must be probated if executed in metropolitan cities. Benami transactions, prohibited under Prohibition of Benami Property Act 1988, which empowers authorities to attach properties and prosecute with imprisonment up to 7 years. Religious or charitable property requires approval under Waqf Act 1995, Charitable and Religious Trust Act, or endowment laws of the relevant state. Now we also have Hindu Endowments Act to govern any such property falling within the ambit of Hindu religion or the charitable properties. Now in conclusion, the joint development agreement is a potent tool for real estate creation, but if entered into without clarity of title, it becomes a slow burning fuss towards inevitable litigation. Because true profit is realized only when risk is mitigated, compliance is respected, and litigation is avoided. Thank you, Ashutosh.